Today on Categorical Imperatives, I need to explain why all these conservatives who are whining about the Supreme Court decision in the case of Texas versus Pennsylvania have no idea what they are talking about. So today, I am going to be breaking down the case and showing why the court absolutely made the right call and why it is preposterous for conservatives to complain about this case being some kind of betrayal of the American people. Hey, greetings and welcome back once again to Categorical Imperatives. As always, I am Locking Liberal, and I want to thank you all so much for being here with me today. If you're new to the program, I want to welcome you. This is a podcast where we are going to be using legal theory and moral philosophy to discuss current events related to law, politics, and culture. Now, for any of my regular listeners, watchers, whatever out there, you might be expecting my part 2 video on the Bill of Rights, and that is coming. I actually have that video made and ready to go. It's just the arguments about this lawsuit are just really getting to me, and I really need to address this, and so that is what we are going to be doing today. Now, this is an episode I did not want to have to make, largely because it involves me calling out a lot of people whose opinions I really respect. But it is getting very tiresome hearing people claim that the reason the Supreme Court rejected this suit has something to do with anything other than the law. And I think most of the bad arguments that I've been hearing can be summed up fairly well by this short little 1-minute clip from Bill Whittle.
United States Supreme Court rejected the case that Texas brought against the states responsible for what they claim was election fraud, and how many other states joined it? 29 others, something like that, 28. And when this rejection of the suit on grounds of standing was first announced, the comment I saw first was from a woman who said, "We are citizens of the United States of America. What's our standing? Where do we get our day in court? At what point do we have a chance to have some kind of confidence that some sort of legal authority has been involved on this?" But she's just whistling past the graveyard, because the Supreme Court did not take the case. The Supreme Court didn't look at the case. The Supreme Court rejected the case on the basis of standing, and whether they had a legal justification for rejecting it on that grounds, in my opinion, they absolutely had a moral obligation to take that case and produce some kind of a judgment, some kind of a ruling on this entire election, and they didn't. And I think that's just rank cowardice. Steve?
So let's get into why Texas versus Pennsylvania is right, and why the Supreme Court was absolutely right. And why Trump supporters are entirely wrong, and why their expectations of how the court should have handled this case are really just an insistence on the very same kind of judicial activism that they rightly condemn when it comes from the left. Now, I'm making this video largely so people will have something that they can point to when anyone they know starts complaining that this lawsuit was cowardice, that it was somehow unconstitutional for the court to not hear it, that this decision was on shaky legal ground, or even that the Supreme Court is the right place for this kind of election dispute to be decided, because it isn't. None of those things are true. And I'm hoping maybe seeing an argument about why constitutional law scholars and attorneys have been saying since we got a hold of this suit that it would be thrown out for a number of procedural obstacles not overcome and jurisdictional claims not proven, broken down, as I always try to do here, in a manner that makes things easily understood by lawyers and non-lawyers alike, just maybe might help persuade them that they are wrong. So, Texas Attorney General Ken Paxton had asked the Supreme Court to intervene in the 2020 presidential election. Yet, rather than seek SCOTUS involvement in a pre-existing election case such as those filed by the Pennsylvania legislators, the Trump campaign, or others, A.G. Paxton decided to initiate his own suit attempting to invoke the Supreme Court's original jurisdiction. This suit is, without question, one of the most audacious legal filings in the whole of the 2020 presidential election sort of court bonanza that we've been experiencing. And it was always quite unlikely that the Supreme Court would respond favorably to Texas' plea. So in this case, Texas AG Paxton has had filed suit against 4 states, Georgia, Michigan, Pennsylvania, and Wisconsin, alleging that various changes to election rules and procedures in those states, combined with an election fraud, tainted the election results in those states. Because this case is styled as a suit filed by one state directly against the other state, the suit invokes the Supreme Court's original jurisdiction as opposed to their normal appellate jurisdiction. And accordingly, A.G. Paxton filed a motion for leave to file a bill of complaint, which is the way that a state asks the Supreme Court to hear a case brought directly against another state under its original jurisdiction, bypassing the need for to first bring the case before a lower court. Now, the full filing, which also includes a bill of complaint, a brief in support of the motion to leave, a motion for expedited consideration, and a motion for a preliminary injunction and temporary restraining order, raises the full panoply of constitutional and other claims that others have seen in the 2020 presidential election litigation thus far, and seeks to turn alleged election irregularities and statistical anomalies into constitutional violations. Now, only 3 attorneys are listed on the filing. A.G. Paxton, recently appointed First Assistant Attorney General Brett Webster, and D.C. Attorney Lawrence J. Joseph, who is only listed as a special counsel to the Attorney General. As noted, there has been a great deal of turmoil in the Texas AG's office, leading to a substantial turnover within the office. Now, the Texas Solicitor General, Kyle Hawkins, is conspicuously absent, and perhaps had the Supreme Court heard the case, Senator Ted Cruz would have volunteered to argue the case before the court, as he had offered to do in other cases of election litigation, but we'll never know. Anyways, so Texas alleged that the 4 defendant states violated their own laws in making changes to their election procedures and violated the Constitution by authorizing or allowing different treatment of different sets of voters within their states. Because these claims would not be enough by themselves to overturn the Electoral College results, the complaint seeks to shoehorn in election fraud claims into an argument by alleging voting irregularities that would be consistent with the unconstitutional relaxation of ballot integrity protections in those state election laws, and repeats a number of unfounded or unsubstantiated charges related to things such as missing USB drives, statistical disparities in election results, failing to prevent such irregularities. Texas claims contributed to the constitutional violations alleged. Specifically, Texas claims that by taking or allowing non-legislative actions to change the election rules that would govern the appointment of presidential electors, the defendant states have violated the Electors Clause, the Equal Protection Clause, and the Due Process Clause. The filings further ask the Supreme Court to prevent the defendant states from appointing electors based on certified election results and require the defendant state legislatures to appoint electors directly. Now, Article 3 of the Constitution provides the Supreme Court with jurisdiction to hear cases in which one state sues another in its original jurisdiction, but it does not always do so. Under current practice, states ask court for permission to file such suits, hence the motion for leave that was filed, and the court does not always oblige. So, for instance, when Nebraska and Oklahoma sought to sue Colorado over the latter's decision to legalize marijuana, the Supreme Court refused to hear that case outright as well. Here, Texas is not only asking the Supreme Court to hear the case, it is also asking for an expedited consideration and extraordinary emergency relief in the form of injunctions barring the defendant states from relying upon the election results to appoint electors and authorizing, pursuant to the court's remedial authority, the defendant states to conduct a special election to appoint presidential electors. In effect, the suit is asking the U.S. Supreme Court to supervise the presidential election in these 4 defendant states. Setting aside the merits of the case for a moment, the Texas filing raises a range of jurisdictional questions. Among other things, Texas has to overcome a range of obstacles, including standing and the political questions doctrine, to press this suit. Texas claims it will be harmed if the allegedly unconstitutional actions within the defendant states determine the presidential election, yet the Constitution provides that Congress is the ultimate judge of the Electoral College results. This is yet another reason why it is hard to see the Supreme Court accepting Texas's plea. Further, the standards for this sort of emergency relief Texas seeks are quite high. Among other things, the party seeking such relief is supposed to show a likelihood of success on the merits, so it seems likely the court will, it seemed likely from the beginning that the court would deny these various motions, and that, as had been hoped, they would do so without too much delay. Now, the first brief supporting Texas to be filed came from 17 state attorneys general, led by Eric Schmidt of Missouri. This is a very squirrely brief. On the one hand, the brief claims numerous non-legislative officials violated the Constitution by making changes to election rules to account for COVID-19, much like what happened in Texas, but I guess we're not talking about that, are we? And that such changes increased the risk of fraud, and that Texas had raised important questions about election integrity, and that the court needed to address them. On the other hand, it confines itself to the Electors Clause claims. It never mentions the Equal Protection Clause or due process claims, and never endorses the Lone Star State's call for extraordinary relief or the invalidation of presidential electors. So, at times, the brief speaks aggressively of unconstitutional encroachments on the authority of state legislatures committed by officials in the defendant states. At other times, the brief merely notes that Texas alleges unconstitutional actions. It is almost as if these portions of the brief were written by different sets of attorneys, which is possible given the speed with which this was put together. Personally, it would not surprise me if some AGs wanted to endorse the Texas arguments whole hog, while others wanted to maintain a critical distance, and this internal tension was never resolved. Now, taking the brief as a whole, it seems clear that at least some of the signatories were hoping to appease Trump supporters within their states and perhaps forestall primary challengers in future elections, but do so without endorsing the Texas arguments in total. I cannot imagine that all the AGs are comfortable with the idea that one state can sue to challenge the way another state conducts its elections. And is this really a precedent that attorneys general who signed on want to set? Do red states really want to create a precedent for blue states challenging their election rules? And if you doubt that could happen, consider that in 1966, Delaware tried for an equal protection claim against New York, objecting to the latter's winner-take-all means of allocating electoral votes. This system, Delaware claimed, diluted Delaware's electoral votes and the votes of its citizens. By supporting the Texas suit, these AGs are virtually inviting more of this sort of litigation. Now, note that if state legislatures or candidates believe that non-legislative actors have violated the legislatively authorized election scheme in a given state, they have ample ability to press such claims in state court, provided they do so in a timely manner. And state legislatures retain the ability to act if an election does not result in a certified result that produces the selection of presidential electors. In other words, accepting the principle that state legislatures must set election rules does not lead to the conclusion that one state can sue another for adopting the wrong set of election rules. Arizona also filed a motion for leave to file an amicus brief, but without the brief attached, as is traditional, stressing the need to resolve this dispute quickly. As promised on Twitter, the president has joined the fray. Professor John Eastman has filed briefs on behalf of Donald Trump seeking to intervene in the case and endorsing the calls to enjoin the defendant states from appointing electors in accordance with their certified election results. The brief opens by discussing how many Americans believe that the election must have been stolen because Trump increased his share of non-white voters and won some bellwether states such as Ohio and Florida, as well as a number of bellwether counties. It has a section of, quote, additional facts that is focused on Georgia and claim that the rate at which absentee ballots were rejected in Georgia dropped precipitously. Yet these claims are directly contradicted by the Georgia Secretary of State. Oh, by the way, all of these documents that I am referencing here, all of the various legal documents that I am talking about, will have links to them down in the description, explaining what each document is and taking you right to it, so you can go and you can peruse these documents for yourself. And I strongly encourage you to do that, by the way. Go read them and then, maybe listen to the show and read them as I'm talking about them, if that will help you kind of take the information in better. I don't know, just do whatever you want. All the information will be down there for you. I'll just leave it at that. So anyways, on the legal issue, the Eastman-Trump filing follows Texas in identifying the kernel of a valid legal argument, being that state legislatures determine the manner of selecting presidential electors, and on that basis asserting that any and all actions taken by executive branch officials, state election officials, and state courts affecting election rules are therefore unconstitutional. And while it is true that state courts cannot wholly rewrite state election law, as some would argue the Florida Supreme Court did in 2000, there is nothing in the Constitution that prevents state legislatures from delegating authority to state election officials or authorizing state courts to adjudicate election-related disputes as part of the overall legislative scheme, as the three-justice concurrence in Bush v. Gore affirmed. It is an indication of how extreme the Eastman-Trump arguments are that they go well beyond the bounds of the Bush concurrence. And today also saw the submission of a brief of so-called constitutional attorneys, including disgraced former Alabama Supreme Court Justice Roy Moore, who is a man who has proven time and time again that he does not understand the Constitution, who also filed a brief arguing that the Constitution endorses Texas arguments, and then goes on to argue that advance voting schemes are unlawful, while stopping short of alleging that absentee voting is unlawful. Now, I think maybe saving the best for last, there is also an amicus filing on behalf of lawyers and others who have served in governments or on behalf of Republicans, including Carter Phillips, Stuart Gerson, Donald Ayer, John Bellinger III, and John Danforth. It also includes a few prominent conservative academics, including Michael Stokes Paulson and Reason's own Keith Whittington. It highlights the extreme nature of what Texas is requesting and is directly aimed at the court's conservative justices. So here is just a little taste of what that document has to say. There are myriad reasons to deny plaintiffs' motions. The amici brief focuses on 1. The Constitution does not make this court the multi-district litigation panel for trials of presidential election disputes pursuant to the Electors Clause and Title III, the U.S. Code, subsection 5. State legislatures have made state courts the tribunals for presidential election disputes. The court's only jurisdiction is appellate. Now, the Electors Clause and 3 U.S.C. Section 5 contradict the plaintiff's unprecedented argument that a presidential election dispute is a controversy between 2 or more states. These provisions contradict the plaintiff's arguments by authorizing each state to delegate by statute the adjudication of all controversies or contests concerning federal presidential election results in that state to that state's courts. Such statutory delegation to state courts is part of each state legislature's chosen statutory manner for presidential elections as much as the statutes on, for example, mail-in voting. A state's chosen manner applies exclusively, according to McPherson v. Blacker, case from 1892, absent some other constitutional constraint, according to Sciallo v. Washington, with an emphasis added that there is no constitutional constraint against state courts being the trial courts for presidential election disputes. Moreover, 3 U.S.C. Section 5 expressly and properly enables a state to designate its state tribunals as conclusive arbiters of any controversy in contest concerning presidential election results in that state. In the rare instance that a state Supreme Court's ruling violates a federal constitutional provision or statute, this court has appellate jurisdiction, as you can see from Bush v. Gore. The plaintiff's motion make a mockery of federalism and separation of powers. It would violate the most fundamental constitutional principles for this court to serve as the trial court for presidential election disputes. Federalism and the separation of powers protect our liberties. They reference Shelby County v. Holder, and they divide power among sovereigns and among branches of government precisely so that we may resist the temptation to concentrate power in one location as an expedient solution to the crisis of the day, according to New York v. United States. Consistent with these principles, the Constitution and Congress have enabled each state to provide law and to adjudicate in its courts all controversies about the presidential election in that state. This court should reject the plaintiff's request to transfer the powers of 50 state court systems to this court. The caution of Rucco v. Common Cause fits even more here. What the plaintiff seeks is an unprecedented expansion of federal judicial power. The expansion of judicial authority would not be into just any area of controversy, but into one of the most intensely partisan aspects of American political life. That intervention would be unlimited in scope and duration. It would recur over and over again around the country with each presidential election. Consideration of the impact of today's ruling on the democratic principle cannot ignore the effect of the unelected and politically unaccountable branch of the federal government assuming such an extraordinary and unprecedented role. Now, my only personal quibble with that brief is that I'm not sure. I personally would deny Texas' motion for leave. Rather, I would be inclined to grant the motion and then deny the request for emergency relief and dismiss the case for lack of jurisdiction and a failure to state a claim for which relief can be granted. The end result, however, would be exactly the same. And what's interesting is that people talk about how Justices Thomas and Alito dissented, and they talk about the fact that those justices say, we should have heard this case, which is true. They say we should have heard the case, But what it seems like all these people talking about this tend to leave out is that Alito and Thomas then go on to make that exact same argument that I said I would personally make here, that they should hear the case and they should hear the case and deny the request for emergency release and dismiss the case for lack of jurisdiction and a 12b6 failure to state a claim for which relief can be granted. So they always seem to conveniently leave that part out. Yes, two justices says they should hear the case. They said that they should hear the case so they could tell the attorneys in the case that the case lacked jurisdiction and tell them why they were throwing it out and why they had no interest in granting the injunctive relief asked for. So it's weird how they always leave that part out. Now, this all brings up the Texas AG Ken Paxton's reply, or rather, I guess, replies, as there are multiple filings, including a motion to enlarge the word count of a supplemental declaration dated from today from Charles Cicchetti, and a new affidavit prepared just the other day from Lisa Gage. The first reply brief focuses on rebuttals and factual and legal claims made by the four defendant states. The brief starts with the facts, and AG Paxton's choice of emphasis here is quite interesting, as his brief leads with an extended defense of statistical stupidities essentially contained in the initial filing and the Cicchetti Declaration. Hence, the newly drafted supplemental declaration, which is attached here. The Paxton brief argues that Dr. Cicchetti did take into account the possibility that votes were not randomly drawn in the later time period, but as stated in his original declaration, he is not aware of any data that would support such an assertion. In other words, because he does not know anything about the two sets of voters, it is okay to assume that they were identical for the purposes of assessing the statistical likelihood that they would vote differently. And that this is the lead argument in the reply tells you most of what you need to know. Maybe, perhaps not. As other parts of the factual discussion misrepresent claims made by the defendant states and repeat claims that were already considered and rejected in other suits over the past month. But on the law, the Texas reply essentially argues that the handful of attorneys in the Texas AG's office who were willing to sign on to the brief know more about the election laws of Georgia, Michigan, Wisconsin, and Pennsylvania than do the attorneys general and secretaries of state of those various states. It further argues that although state legislatures do have plenary authority to set the manner in which state select electors, this somehow does not include the authority to authorize the involvement of courts and election agencies, and that the U.S. Supreme Court, not the Supreme Courts of the respective states, should be the final authority on the meaning of relevant state laws and constitutional provisions. So, hooray for federalism. So, the other Texas filing, styled as a reply in support of Texas's plea for emergency injunctive relief, is not much better. It does, however, deploy a powerful use of capitalization in the table of contents. The case says Texas is likely to prevail, as though capitalizing the word is the same thing as offering evidence of why they are likely to prevail. Now, I think it's interesting that they're doing this now because they don't have to worry about any of the defendant states responding in kind. I don't know what would be stopping stopping Pennsylvania, Wisconsin, Georgia, Michigan from just filing their own reply brief saying Texas is not likely to prevail, as though capitalizing is not makes their claim any stronger. Why is this an illegal brief? This is ridiculous. Anyways, in this brief, Texas argues that it is not seeking to disenfranchise voters. Rather, they argue that the defendant states' maladministration of the 2020 election makes it impossible to know which candidate garnered the majority of lawful votes. Of course, to the extent this were true, Supreme Court intervention would not be necessary. if the relevant state legislatures concluded that the results of the elections within their states were indeterminate, that the voters had failed to select electors on election day, they could act, but they have not. Here, Texas repeats its arguments that federalism requires the Supreme Court ordering state legislatures to act and possibly even hold new elections because Texas doesn't like the outcome of the election. Just a little tidbit, the Texas reply briefs include a longer list of lawyers than the original filings, but do not include the folks that one might expect to have seen on the state's brief to the Supreme Court. So, for example, Texas Solicitor General Kyle Hawkins still does not make any appearance in support of this filing, but the Attorney General's Chief of Staff, Leslie Henneke, and the Deputy Attorney General, Aaron Retzpoll, too. So it almost appears, looking at this, which a quick Westlaw search, that neither Heineke or Retz had submitted legal filings of any sort before this, although perhaps I missed something, but to me, it almost looks like as if A.G. Paxton is requiring all of his staff to go down with his sinking ship. Now, one final note. We have seen some truly bad legal filings in various 2020 election lawsuits, but we have not until this case seen such bad lawyering from offices and institutions known for serious legal work. Texas v. Pennsylvania has been a notable exception, and it is particularly notable to see such bad lawyering from the office of a state attorney general, and let us hope we do not see much more of this. Now, to summarize my view of this case in brief, the case filed by Texas is not a lawsuit. It is a press release masquerading as a lawsuit. Texas doesn't have standing to raise these claims as it has no say over how other states choose electors. It could raise these issues in other cases and does not need to go straight to the Supreme Court. It waited too late to sue. The remedies Texas suggests of disenfranchising tens of millions of voters after the fact is absolutely unconstitutional. There's no reason to believe the voting conducted in these states was done unconstitutionally. It is too late for the Supreme Court to grant a remedy, even if the claims to the case were meritorious, and they are not meritorious. The fact is, anyone who is so sure that this is some kind of corrupt bargain and that the highly conservative-leaning Supreme Court, who has 3 justices who were appointed directly by Trump, are all just conspiring against him in some kind of massive conspiracy on every level of government, from the federal down to the local, because Donald Trump says so, is a person suffering from a right-wing version of TDS. And there is a Trump derangement syndrome for those who are on the right, just as much as there is for those who are on the left. And that is the conservative right-wing TDS is essentially when everything a serial liar like Donald Trump says is taken to be true, even without evidence, and even with evidence to the contrary showing why he is wrong. They believe Donald Trump was cheated. Why? Because Donald Trump told them he was cheated. This has all the credibility of Hillary Clinton claiming that Donald Trump stole the election from her because Russia is bad and Putin is bad. And even though I haven't asserted a single fucking shred of evidence that Donald Trump is Putin's bitch, Donald Trump is totally Putin's bitch. He's a Russian agent. I have no evidence, but I don't need evidence. You just need to believe me. Trump stole this election from me. This is the exact same argument. This is no more solid than Hillary Clinton's 2016 claims about the Russia, whatever, the Russia hacking, Russia election stealing, all of that stuff. So, yeah, anyways, if you liked this episode today, just take a moment and subscribe to the channel, and consider smashing that like button if you want. And if you want to leave me a comment, I do definitely welcome all comments, whether you agree with me or disagree with me. I mean, I'm right, but if you think I'm wrong, you're certainly welcome to share your opinion about why you think I'm wrong, or anything else you might want to say. So I really do would love to hear from people and hear their thoughts on this. Do you agree with me? Do you disagree with me? Do you think there's something I missed? Is there something that I brought up that was maybe especially informative to you? That just anything like that, I would love to hear from you guys. And like I said, I will be having links to all of the legal briefs down in the description. And I encourage you to go read through them and get acquainted with the actual filings for yourself. And then hopefully this video will be a handy guide to help you kind of just break them down and get past a lot of the legal jargon and understand the basic argument that was being made there. So anyways, thank you so much for tuning in to Categorical Imperatives. I will be back very soon in the next couple days. In the next day or two for sure, with my second part video about the Bill of Rights. And so until then, Delenda es Carthago.